Your Honor, I'd like to start by responding to a point that Mr. Robert made before I go into the multiple points I plan to address. I understand the prosecutor's characterization of Paul as being the enforcer, as being the primary one. But I believe part of that is based simply on the evidence that we have. This court's heard the text messages, extensive text messages, of Ms. Vander Ark instructing Paul on what he was to do to Timothy. You've heard Paul's testimony about what he was instructed to do and what he did. The rest of the time, when she was there doing whatever she did, Paul was at work. She didn't have to send text messages to herself. Timothy's not here to talk about what happened when it was just him and his mother. So I disagree with that characterization. I believe, based on what we do know of Ms. Vander Ark, that there was far, far more that went on. There was far, far more that she did that there simply is no evidence of, no one to speak of, because the only person alive who knows what she did is her. Beyond that, reading the pre-sentence report in this case, I can't argue with the reasonableness of the recommendations in the pre-sentence report. I also really can't add anything about the offense, about the details of what happened to Timothy. You presided over the same trial that I watched. I know in motions, other paperwork submitted to the court, you're aware of far, far more than what came out publicly, what was submitted to the jury. But I'd ask the court to consider, I think there's 5 fronts on which Paul should be evaluated very differently than where his mother is. And the first is just capacity to understand. We heard Ms. Vander Ark's attorney argue they didn't know what they were doing. They didn't realize that it could kill him or cause that level of injury. And I don't have to come to a conclusion. I don't have to say I think that's right or that's wrong to understand that a 41-year-old law school graduate who was, by her own boasting, at the top of her class, who passed the bar with flying colors, who would have been an attorney, well, academically was qualified to be an attorney. We never got an answer of why she wasn't. And who worked for the court both from a legal front, from a moral front, from an intellectual front, had far, far more capacity to understand what she was doing and the potential consequences of what she was doing than her son, who was a 20-year-old high school graduate who worked as a dishwasher. There's simply no comparison in capacity, in life experience, in an ability to understand and recognize what was happening. Second, well, we recognize, for purposes of the child abuse statute, for purposes of Paul's plea, the law may not distinguish between a parent and another person over the age of 18 who's placed in charge of a child. We all know a mother has a very different role than a sibling. We all know that there's a certain level of rivalry, a certain level of competition that we expect between siblings, which is very different than the care that we expect from parents. Third, I'll come back to the text messages. It was very clear Paul was the follower and his mother was the leader in this case. Listening to over an hour of text messages read during her trial, there's pieces missing. We don't get the whole story because she talked to him over the camera, or she talked to him on the phone, or she talked to him in person. But what is very clear from those text messages is there is not a single time that Paul gives an instruction. Every single time an instruction is given, you need to do this, it is given by her. Fourth, and Mr. Roberts has addressed this regarding Paul's cooperation. Once the gravity of what happened sank in, I believe from the reports that was a day or so after, Paul has shown remorse. He's shown confusion over how he could have done this and recognition that it was wrong. He's testified honestly. He's fully cooperated in many areas in ways that were not of clear benefit to him. His mother did none of these things. She took the stand and lied, redirected. It's not my fault. I didn't do anything wrong. And fifth, and I think very important in looking at the evaluation of Mr. Ferguson, it's very clear that he and his other siblings were also victims of their mother. CPS involvement going back to when they were in elementary school, back when Timothy was 18 months old. A third grade teacher who said Paul and Nolan are secretive about what happens at home. They're not supposed to talk about it. So when Mr. Johnson argued in cross-examination to Paul, why didn't you report it to somebody? A lifetime of being told you're not supposed to talk about what goes on at home. A lifetime of being isolated, separated from peers, having no meaningful social contacts outside his household. That all started with her. A record that when Timothy was 18 months old, when Paul was 7, that Timothy was underfed, failure to thrive. Paul didn't have anything to do with that. He was 7. But that was the pattern. That was his entire life. That was his entire framework. That was what she taught him from the beginning, or at times failed to teach him through neglect. Mr. Roberts referenced, and I don't remember if it was in sentencing or in his closing argument, that the difference between Timothy and Paul was that Paul was useful. Timothy wasn't. At least not to their mother. And I wouldn't disagree with that characterization. But I think that's important for the court to consider. Timothy was treated the way he was because he wasn't useful. That's how children in their mother's household were treated if they weren't useful. And I believe at some level, some part of Paul understood that. He understood that we do these things to Timothy because he misbehaves, because he doesn't follow instruction, and because he's not useful. And part of understanding that is also understanding that if he didn't follow instructions, if he misbehaved, if he got on her bad side, that he could once again be subject to some of the same mistreatment. On the neglect front, I don't think any of them ever ceased to be subject to that mistreatment. And I'll end with his mother's own words from the text messages read in court. To Paul, quote, "If he falls asleep from you, not watching, that is not going to end well for either.
If I could just make one more brief point, and it's not in response to anything that Mr. Elvin Brady has said, but the court referenced that it's had a lot of outside people contacting the court. I certainly have had that as well. And one of the consistent themes there is people believing that Paul suffers, or not suffers, it's not a suffering. That Paul is on the autism spectrum. I think it's important to note that in both of these evaluations, that's not borne out. Certainly people may have that belief and think that that should be a factor here, but there's nothing in either one of these reports that supports that conclusion. So I just want to note that. That is certainly something that I think the court could have considered, but there's nothing in the report that would support that, and I don't think Mr. Eldon Brady would disagree with that point.
Yeah. I was going to reference that in my comments as well, so.
Your Honor, I think the reports do bear out that some of the characteristics that those individuals are observing and coming to that conclusion are connected to that neglect and abuse, and I believe it was Dr. Farrak characterized as normalization of abnormal behavior. So while I agree that both analysis seem to have come to the conclusion that that diagnosis is inappropriate, I don't believe that those observations by the individuals mentioning that are ungrounded. It's simply that those behavioral characteristics come from a different source and therefore do not lead to the ability to officially diagnose with that condition. That does not change the fact that those characteristics are there, that those characteristics are relevant to Paul's interactions with his mother, or that those characteristics are relevant to ongoing treatment services that Paul will need moving